9-203.1 Purpose. The purpose of this bylaw is to protect the floodplains, wetlands, and related water resources, riverfront areas, and adjoining upland areas in the town of Southbridge by prior review and controlling activities deemed by the Southbridge Conservation Commission, hereinafter the Commission, likely to have a significant or cumulative effect on the wetland resource area or resource area values, including but not limited to the following: public or private water supply, groundwater, water quality, flood control, sedimentation and erosion control, storm damage prevention and flowage, water pollution control, wildlife and wildlife habitats, fisheries, shell fisheries, rare plant and animal species, agriculture, aquaculture, and recreation values deemed important to the community, collectively the resource area values protected by this bylaw. This bylaw is intended to utilize the home rule authority of the town of Southbridge so as to protect the resource areas under the Wetlands Protection Act, MGL, Chapter 131, Section 40, hereinafter the Act, as amended from time to time, to a greater degree to protect the additional resource areas beyond the Act recognized by the town as significant, to protect all resource areas for their additional values beyond those recognized in the Act, and to impose in local regulations and permits additional standards and procedures stricter than those of the Act and regulations thereunder, 310 CMR 10 as amended from time to time. Subject, however, to the rights and benefits accorded to agricultural uses and structures of all kinds under the laws of the Commonwealth and other relevant bylaws of the town of Southbridge. Unless otherwise indicated in this bylaw and these regulations, definitions, timeframes, forms, and procedures shall be the same as those stated in the Act. With required local commission identification, notification, and documentation, the commission and its agents, officers, and employees shall, with 24 hours notice to the property owner, except in the event of an emergency, have authority to enter upon privately owned land for the purpose of performing their duties under this bylaw, and may make or cause to be made such examinations, surveys, or sampling as the commission deems necessary, subject to the constitutions and laws of the United States and the Commonwealth, so long as property owner consents to the entry or an administrative search warrant is issued by a court. See Mass General Law, Chapter 131, Section 40, as amended. Section 9-203.2, Jurisdiction. Except as permitted by the Commission or as otherwise provided in this bylaw, no person shall commence to remove, fill, dredge, degrade, discharge into, alter, or build upon the following resource areas: freshwater wetlands, marshes, wet meadows, bogs, swamps, vernal pools, banks, reservoirs, lakes, ponds of any size, lands under water bodies, land subject to flooding or inundation by groundwater or surface water, any land bordering thereon. Bordering in this context shall mean either the greater or of the following: A, 100 feet horizontally perpendicular to the bank of any freshwater wetland, marsh, wet meadow, bog, swamp, vernal pool, inclusive of uncertified vernal pools, bank, reservoir, lake, and pond. B, 100 feet horizontally perpendicular to the water elevation of the 100-year storm. C, 200 feet horizontally perpendicular to the mean annual high water elevation of any stream, perennial or intermittent, or river. In addition, it is the policy of the Commission to advise applicants on these non-regulated wetland resource areas: D, intermittent streams up gradient of wetland resource areas; E, isolated land subject to flooding below 310 CMR 10.57 size thresholds; and F, isolated wetlands less than 5,000 square feet. The Commission will make every effort to identify these areas at the site, will recommend locating them on the plans, will encourage applicants to avoid impacts to these areas, and will suggest possible measures to mitigate unavoidable impacts with respect to drainage and flood control. The jurisdiction of this bylaw shall not extend to uses and structures of agriculture that enjoy the rights and privileges of laws and regulations of the Commonwealth governing agriculture, including work performed for normal maintenance or improvement of land and in agricultural or aquacultural uses, as identified by 310 CMR 10.04. 9-203.2a, vernal pools. Vernal pools certified by the state shall be considered a resource area. It is the policy of the Commission to protect vernal pools because they provide valuable and increasingly rare wildlife habitat. Because they do not contain water all seasons of the year, a vernal pool must be identified in order to be protected. This can be done at the responsibility of the property owner or developer as part of the determination of applicability or part of the notice of intent review, or prior to these processes by a qualified person. The Commission must be satisfied that the person identifying a vernal pool is qualified to do so. 9-203.2b, rare species. Where the project site warrants, the applicant may be required to submit a quantitative habitat analysis. In areas under the jurisdiction of the Natural Heritage and Endangered Species Program, the applicant must obtain a written decision from the National Heritage and Endangered Species Program indicating the presence or absence of protected or endangered species. 9-203.3, conditional exceptions. The order of conditions and application required by this bylaw shall not be required for maintaining, repairing, or replacing, but not substantially changing or enlarging an existing and lawfully located structure or facility used in the service of the public or to provide electric, gas, water, sewer, telephone, and other telecommunication services, provided that written notice has been given to the Commission prior to the commencement of any such work, and provided that the work conforms to the performance standards and design specifications and regulations adopted by the Commission. 9-203.3a, agricultural work. Any agricultural activity as defined by the Farm Assessment Act, MGL Chapter 61A, to be normal maintenance or improvement of land in agricultural use, and therefore exempt from the provisions of this Act, MGL Chapter 128, Section 1A, and from the Wetlands Protection Regulations of 310 CMR 10, will also be exempt under this bylaw. Additionally, any agricultural activity as defined by MGL Chapter 61A and on land not under the jurisdiction of the Act and 310 CMR 10 will be exempt from all local jurisdiction. However, no animal shall be given free access to any wetland, vernal pool, certified or not, isolated land subject to flooding, marsh, swamp, bog, etc., intermittent or perennial stream, and they must be kept far enough away or below, far enough from or below the level of aforementioned wetlands so that their waste does not impact said wetlands. The application and order of conditions required by this bylaw shall not be required for work performed for normal maintenance or improvement of land. 9-203.3b, emergency work. The application and permit required by this bylaw shall not be required for emergency projects necessary for the protection of the health and safety of the public, provided that the work is to be performed by or has been ordered to be performed by an agency of the Commonwealth or a political subdivision thereof, provided that written advance notice has been given to the Commission prior to commencement of work or within 24 hours after commencement, provided that the Commission or its agent certifies the work as an emergency project, provided that the work is performed only for the time and place certified by the Commission for the limited purposes necessary to abate the emergency, and provided that within 21 days of commencement of emergency projects, a permit application shall be filed with the Commission for review. Upon failure to meet these and other requirements of the Commission may, after notice and public hearing, revoke or modify any emergency project approval and order restoration and mitigation measures. 9-203.3c, waivers. Strict compliance with this bylaw may be waived when, in the judgment of the Commission, such action is in the public interest and is consistent with the intent and purpose of the bylaw. Any request for a waiver must be submitted to the Commission in writing, stating why a waiver is desired or needed, is in the public benefit, and is consistent with the intent and purpose of the Wetlands Protection Act and this bylaw. All waiver requests shall be presented at the time of filing.
9-203.4 Filing Requirements and Procedures. 9-203.48 Permits. Written applications shall be filed with the Conservation Commission to perform activities affecting resource areas protected by this bylaw. The permit application shall include such information and plans as are deemed necessary by the Commission to describe proposed activities and their effects on the resource area protected by this bylaw. No activities shall commence without receiving and complying with a permit issued pursuant to the bylaw except as certified to be an emergency under Section 9-203.3b above. 9-203.4b, determinations. Any person desiring to know whether or not a proposed activity or an area is subject to this bylaw may in writing request a determination from the Commission on the appropriate form. The request shall contain all necessary information, plans, data calculations, etc., as specified by the regulations. The Commission is in an appropriate case may accept as the application and plans under this bylaw any application and plans filed under the Act and 310 CMR 10, but the Commission is not obliged to do so. At the time of the permit application, the applicant shall pay a filing fee according to the schedule in the Associated Southbridge Wetland Protection and Conservation Bylaw rules and regulations. This fee is not refundable. The fee is in addition to that required by the Act 310 CMR 10. 9-203.5 Notice of Hearings. The applicant filing a request for determination or application for permit under the provisions of this bylaw shall give written notice with proof of mailing or by hand delivery to all the abutters within 100 feet of the property lines of the property in which the project is to occur according to the current assessor's records 5 days in advance of the scheduled hearing in accordance with provisions of this bylaw and its regulations. The Commission is responsible for notifying the applicant and owner, if not the same, of the time, place, and place of the scheduled hearing. Also, the Commission is responsible for placing a notification of the subject hearing in a local newspaper at least 5 days prior to the hearing. The Commission shall conduct a public hearing within 21 days of the receipt of the completed application for permit or request for determination unless unusual circumstances prevent this scheduling. Under such circumstances, the hearing shall be scheduled at the next regularly scheduled Commission meeting, having time available. The Commission may, at its option, combine the hearing under this bylaw and the hearing conducted under the Act. The Commission shall have the authority to continue the hearing to a specific date agreeable to the applicant, announced at the hearing without further notification for reasons stated at the hearing. Those reasons may include, but are not limited to, requests from other boards, officials, or attendees. In the event that the applicant objects to a continuance, the hearing shall be closed and the Commission will take action on available information. 9-203.6 Notification to other town officials, boards, and commissions. At the same time it advertises the public hearing, the Commission shall notify the Department of Public Works, Planning Board, Zoning Board of Appeals, Board of Health, Building Inspector, and any other relevant municipal body regarding the application before the Commission. The Commission shall not take final action until such boards and officials have had 7 days receipt of the notice to file written comments and recommendations with the Commission. The Commission shall take into account any comments or recommendations, but they shall not be binding on the Commission. The applicant shall have the right to receive any such comments and recommendations and to respond to them at the public hearing prior to final action. 9-203.7, Public Hearings, Permits, and Conditions. If the Commission, after a public hearing, determines that the activities which are the subject of the application are likely to have a significant or cumulative effect upon the wetland values protected by this bylaw, the Commission, within 21 days at the close of the hearing, unless unusual circumstances prevent it, shall issue or deny a permit for activities requested. Determinations of applicability will be issued within 21 days of receipt of the request. If the Commission issues a permit, conditions shall be imposed which are deemed necessary to protect the interests and values, and all activities shall be performed in accordance with those conditions. The Commission is empowered to deny a permit for failure to meet the requirements of this bylaw, for failure to submit necessary information and plans requested by the Commission, for failure to avoid or prevent unacceptable, significant, or cumulative effects, to avoid or prevent unacceptable, significant, or cumulative effects upon the wetland values protected by this bylaw, and where no conditions are accurate to protect those values. A permit shall expire 3 years from the date of issuance. The Commission may issue a permit expiring 5 years from the date of issuance for reoccurring or continuous maintenance work, provided that annual notification of time and location of work is given to the Commission. Any permit may be renewed once for an additional 1-year period, provided that the request for renewal is received in writing by the Commission 30 days prior to expiration. The Commission, for good cause, may revoke or modify a permit issued under this bylaw after notice to the holder of the permit, notice to the public, abutters, and town boards pursuant to the preceding Section 9-203.5 and a public hearing. The Conservation Commission is in an appropriate case may combine the permit and other action on an application issued under this bylaw with the order of conditions issued under the Act. The Commission may deny the request for an extension and require the filing of a new permit request under the following circumstances. 1, no work has begun on the project except where such failure is due to delays caused by events or processes outside the applicant's control that are clearly identified in the extension request. And 2, new information has become available indicating that the order is not adequate to protect the interest covered by this bylaw. No work proposed in any permit application shall be undertaken until the permit issued by the Commission with respect to such work has been recorded in the Registry of Deeds, or if the land affected thereby be registered land in the registry section of the land court for the district wherein the land lies, and until the holder of the permit certifies in writing to the Commission that the permit has been recorded.
9-203.8, Violations and Enforcement. No person shall remove, fill, dredge, build upon, degrade, or otherwise alter protected resource areas, or cause, suffer, or allow such activity, or leave in place unauthorized fill, or otherwise fail to restore illegally altered land to its original condition, or fail to comply with a permit or an enforcement order issued. 9-203.8A, Identification of violations. Violations can be identified by observations of the Conservation Commissions and commissioners and or its agents, wetland consultants, and citizens. Reports of violations are always confidential. Commissioners and staff may not reveal the source of any report of possible violations. When potential violations are reported, a commissioner, the commission's agent, or a wetland consultant will determine whether a violation exists and if an enforcement order is necessary. The wetland consultant may consult with commission's agent and commissioners as necessary, but if time or other constraints exist, may proceed employing best judgment. A temporary enforcement order or temporary cease and desist order may be imposed by an individual commission member, wetland consultant, or the Commission's agent, but all such temporary orders must be ratified by a majority of the Commission at a public meeting within 21 days and may be extended at such time for any period the Commission deems necessary. 9-203.8B, Violations. If a Commissioner, the Commission's agent, or wetland consultant confirms or strongly suspects a violation, an enforcement order will be issued. Enforcement orders will direct the property owners and contractors to 1, stop work, 2, identify resource areas on the site, 3, install erosion and or sedimentation controls, and 4, meet the Commission to discuss the violation. 2, if a wetland line has been previously approved by the Commission, its location will be basis for evaluation of the violation. If a wetland line has not been established or approved by the Commission, then the Commission or enforcement order may require the owner, developer, and contractor to employ a wetland scientist at the applicant's expense to identify wetland resource areas with flagging within a time frame not longer than 2 weeks from the date of the enforcement order. All enforcement orders will be maintained in the conservation database and placed on file. At the subsequent meeting, the Commission will consider the following aspects of the violation. A, value of the area to the statutory interests. B, harm of the damage. C, immediacy of the harm. D, value of restoration. E, feasibility of restoration. F, potential legal outcomes. G, potential financial burden to the town of Southbridge. 3, the Commission shall have authority to enforce its regulations and permits by the issuance of enforcement orders, administrative orders, and initiation of civil and criminal court actions. Any person who violates the provision may be ordered to restore the property to its original condition and take other action deemed necessary to remedy such violations, fined, or both. The enforcement officer in the non-criminal disposition procedure shall be members of the Conservation Commission or its agents. 4, upon request of the Commission, the town manager and the town attorney shall take legal action for enforcement under civil law. Upon request of the Commission, the chief of police shall take legal action for enforcement under criminal law. 5, municipal boards and officers, including any police officer or any or other officer having police powers, shall have authority to assist the Commission in enforcement. As an alternative to criminal prosecution in a specific case, the Commission shall issue citations under the non-criminal disposition procedures set forth in Mass General Law, Chapter 40, Section 21D. And 6, in addition to any other remedies available under any bylaw, under any law or this bylaw, any person who violates any provision of this bylaw, regulation, permit, or administrative order issued may be fined according to the fine scheduled below. A, the fine for filling in a wetland resource area is $5 per square foot or filled-in resource area per day. Each day or portion thereof during such a violation continues or unauthorized fill or other alteration remains in place shall constitute a separate offense. Also, each provision of the bylaw, regulation, permits, or administrative orders violated shall constitute a separate offense. For example, if unauthorized fill of a wetland amounts to 100 square feet, the Commission or its agents has the right to issue a penalty of $500 for each day unauthorized fill remains in the wetland or resource area. B, for all other violations, each day or portion thereof during which a violation continues shall constitute a separate offense, and each provision of the bylaw, regulations, permits, or administrative orders violated shall constitute a separate offense. 7, pursuant to Mass General Law, Chapter 40, Section 21D, and the Town of Southbridge General Bylaws, Section 1-111, the Commission or its agent may issue the following penalties for wetland violations. In addition to the fine for filling of wetlands, after initial notification by the Southbridge Conservation Commission or its agents. A, first offense, $100 for each day the violation exists. B, second offense, $550 for each day the violation exists. C, third offense, and all subsequent offenses, $200 for each day the violation exists. Fines assessed under this bylaw shall be separate from and in addition to any applicable under the Act. 9-203-9, Construction Standards and Restrictions. 9-203-9A, Sequence of Construction. The applicant shall provide a detailed sequence of construction to the Commission as part of the standard filing requirements, detailing in what order the project's construction will follow. Said sequence shall be followed by the applicant, unless amended and approved by the Commission. 9-203.9B, Wetland Setbacks for New Activities. In order to protect and preserve the public interest and values of the wetlands and waterways of the town of Southbridge, activities in wetland and buffer zone resource areas should be avoided to the full extent practicable. The following are the minimum distance setbacks of activities from the edge of wetlands or vernal pool as per section 9-203.2A. These setbacks are the minimum and may be extended further if deemed necessary for the protection of the interests of the bylaw by the Commission. These setbacks may be reduced if the applicant successfully demonstrates to the Commission that there are no adverse impacts along with a site inspection by the Commission. The setbacks shall be as follows. A, 0-foot setback for wetland-dependent structures, drain, outfalls, weirs, etc. Fences and culverts or bridges necessary for upland access or reasonably alternative access is unavailable. B, 25-foot setback for undisturbed natural vegetation. C, 50-foot no-build setback to the edge of driveways, roadways, and structures. D, 25-foot chemical-free area within which no fertilizers, herbicides, pesticides, or other chemical maintenance substances shall be used. E, 100-foot setback for underground or above-ground storage of gasoline, oil, or other fuels and hazardous materials. F, 100-foot setback of undisturbed natural vegetation to the mean high water line for vernal pools, certified or not, where applicable.
Erosion prevention. Proposed location of all silt and erosion prevention devices such as silt fence or logs and hay bale shall be shown on the plan submitted in the wetland filing furnished by the applicant for Commission review and approval. These devices shall be installed prior to the commencement of activities on the site and maintained until landscaping is established and inspected by the Commission or its agent. 9-203.9D, storage of fill. If any fill is to be stored on site, it shall be stored outside of the buffer zone and covered by an impenetrable barrier tarpaulin. The location of said fill shall appear on any plan submitted to the Commission with the notice of intent. If the Commission determines that the proposed location of fill threatens the area subject to protection, it may require the applicant to store said fill in a different location or to remove it completely from the site. 9-203.9E, construction debris or spoils area. There shall be no disposal or burial of construction debris, i.e. scrap, lumber, metals, concrete, asphalt, piping, logs, stumps, etc., within 100 feet of a wetland. Illegal disposal of said debris shall result in a stop work order, fine, required removal of said debris, or all of the above. The Commission may allow the creation of a spoils area, which would be required to be designated on the project plan, if it is proven that it will not harm areas subject to protection. This spoils area must be protected from the elements as if it were fill, as above. 9-203.9F, wetlands, replication, and requirements. 1. It is the policy of the Commission to follow the no net loss guidelines set forth by the Massachusetts Department of Environmental Protection. Therefore, applicants who propose to alter resource areas under the Commission's jurisdiction must demonstrate that there is no practicable alternative, minimize impacts where they are unavoidable, and mitigate losses of wetland resource area, where applicable or appropriate, on a 1 to 1.5 basis. Limited projects are included in this requirement. The 1.1.5 ratio may be reduced to 1.1 If the applicant successfully demonstrates to the commission that the site will not support a 1 to 1.5 ratio due to the area of the site, slope, soil type, or other natural feature which would adversely affect the created wetland resource area. Projects involving wetlands filing and/or permanent alterations shall meet the requirements of 310 CMR 10.63 and 10.554 and the following requirements of the Commission. A, the proposed replication area design must be submitted to the Commission for approval as part of the submittal of the project notice of intent. Applicants are advised to appear before Commission for preliminary discussion, comments, and review prior to submittal of the replication plan with the notice of intent. B, the replication area must be shown to sufficiently duplicate the functions of the wetland proposed to be altered. C, the replication area shall be constructed to the extent possible immediately after alteration of the existing wetland and during the same growing season. D, the proposed replication area must be clearly flagged for Commission site inspection before the notice of intent filing shall be considered complete, and said flagging shall correspond to flagging shown on the plans. E, the notice of intent submittal for a replication area shall include a detail of replication showing I, cross-section with the indication of groundwater level, soil profile, and thickness of organic soil in the existing and proposed wetlands. II, plant species detail, including species found in the area to be altered, and number, types and locations of species to be introduced into the replication area, which shall be native wetland species. III, detail the stabilization plans for replication area banks, and IV, wildlife habitat diversity plan. F, construction of the replication area shall follow all requirements as set forth by the Commission. 3, if, after 3 growing seasons, the Commission determines that the replication area has not satisfactorily developed into a wetland, the applicant or owner may be required to submit new plans to successfully replace the wetland. No certificate of compliance shall be issued until the Commission has determined that a satisfactory replication area has been completed at the end of the 3-year period. 9-203.10, surety. As part of a permit issued under this bylaw, in addition to any surety required by any other municipal or state board, agency, or official, the Commission may require that the performance and observance of the conditions imposed thereunder, including conditions requiring mitigation work, be secured wholly or in part by one or both of the methods described below. 1, by a proper bond, deposit of money, or negotiable securities under a written third-party escrow arrangement, or other undertaking of financial responsibility sufficient in the opinion of the Commission to be released in whole or in part upon issuance of certificate of compliance for work performed pursuant to the permit. Said bond or other surety shall be payable to the town of Southbridge sufficient as to secure the faithful and satisfactory performance of work required by the final order of conditions in such sum and upon such conditions as the Commission may require. Notwithstanding the above, the amount of such bond shall not exceed either the estimated cost of the work required by the final order of conditions or the estimated cost of the work required for the restoration of affected lands and properties if the work is not performed as required, whichever is greater, but may include a sum to account for reasonably projected inflation if the project will last more than 1 year, including replication time. 9-203.11, appeals. A decision of the Commission shall be reviewable in the Superior Court in accordance with Mass General Law, Chapter 243, Section 4. 9-203.12, Relation to the Wetlands Protection Act. This bylaw is adopted under the Home Rule Amendment of the Massachusetts Constitution and the Home Rule Statutes, independent of the Wetlands Protection Act, MGL Chapter 131, Section 40 as amended, and Regulations 310 CMR 10.00 as amended thereunder. It is the intention of this bylaw that the purposes, jurisdiction, authority, exemptions, regulations, specifications, standards, and other requirements shall be interpreted and administered as stricter than those under the Wetlands Protection Act and regulations. 9-203.13, severability. If any provision of this bylaw is held invalid by a court of competent jurisdiction, such holding shall not affect the validity of the remainder of this bylaw, nor shall it invalidate any order of conditions or determination which previously has been issued. 9-203.14, regulations. After public notice and public hearing, the Commission shall promulgate rules and regulations to affect the purposes of this bylaw. Failure by the Commission to promulgate such rules and regulations or a legal declaration of the invalidity of such regulations by a court of law shall not act to suspend or invalidate the effect of this bylaw. 2, the Southbridge Conservation Commission may from time to time adopt such other and further definitions, regulations, fees, and performance standards as it may deem necessary to protect the interests and/or intent of this bylaw. Said definitions, regulations, fees, and performance standards shall become effective upon publication following a public hearing advertised as per state law. 3, at a minimum, these regulations shall define key terms in this bylaw and establish basic performance standards not inconsistent with the bylaw and procedures governing the amount and filing of fees. 9-203.15, definitions. The following definitions shall apply in the interpretation and the implementation of this bylaw. 9-203.15a, alter shall include without limitation the following activities when undertaken to, upon, within, or affecting resource areas protected by this bylaw. 1, removal, excavation, or dredging of soil, sand, gravel, or aggregate materials of any kind. 2, change of pre-existing drainage characteristics, flushing characteristics, salinity distribution, sedimentation patterns, flow patterns, or flood retention characteristics. 3, drainage or other disturbance of water level or water table. 4, dumping, discharging, or filling with any material which may degrade water quality. 5, placing of fill or removal of material which would alter elevations. 6, driving of piles, erection or repair of buildings or structures of any kind. 7, placing of obstructions on objects in water. 8, destruction of plant life, including cutting of trees. 9, changing temperature, biochemical oxygen demand, or other physical, biological, or chemical characteristics of any waters. 10, any activities, changes, or work which may cause or tend to contribute to pollution of any body of water or groundwater. 11, incremental activities which have or may have a cumulative adverse impact on the resource areas protected by this bylaw. 9-203.15b, a butter, is a landowner as determined by the most recent assessor's records whose land immediately abuts the property which is the subject of notification, or whose land lies across a public or private traveled way or across any river, stream, pond, pond or lake or downstream to a distance of 100 feet. In particular cases, the Southbridge Conservation Commission can add persons to the list of abutters to be notified. 9-20315C, intermittent stream, is a body of running water that does not flow year-round. It may flow in all seasons except during the driest summer months or only after precipitation or when groundwater levels or water from snowmelt are high. There may be little or no vegetation on the rocks, and the only invertebrates that may be species that can tolerate periods of drought. An intermittent stream shall be delineated by a defined permanent channel and bank and the occurrence of two or more of the following characteristics. A, evidence of scour or deposits of recent alluvium or detritus. B, the presence of standing or flowing water for a duration longer than a particular storm incident. C, the presence of hydrophytic vegetation, and or D, the presence of hydric soils. 9-20315D. Person shall include any individual, group of individuals, association, partnership, corporation, company, business organization, trust, estate, the Commonwealth, or political subdivision thereof, to the extent subject to town bylaws, administrative agency, public or quasi-public corporation or body, this municipality, and any other legal entity, its legal representatives, agents, or assigns. 9-20315E. Rare species shall include those invertebrate and invertebrate animal species officially listed, endangered, threatened, or of special concern by the Massachusetts Division of Fisheries and Wildlife under 321 CMR 8 as amended, as well as those plant species listed as rare, threatened, or endangered by the Massachusetts Natural Heritage Program, regardless of whether the site in which they occur has been previously identified. 9-20315F. Stream includes any body of running water moving in a channel in the ground, including intermittent streams, perennial streams, rivers, and headwaters of streams above the point where there are wetlands adjoining them. 9-203.15G. Vernal pool is a confined basin depression which contains a small body of standing water, usually drying out for part of the year during warm weather, as well as the area within 100 feet of the mean annual boundary of such a depression, to the extent that such habitat is within an area subject to protection under MGL Chapter 131, Section 40, as specified in 310 CMR 10.02I, as amended. It can be natural or man-made, and usually lacks a permanent outlet or any fish population. Further, the occurrence of one or more obligate species, including the fairy shrimp, spotted salamander, Jefferson salamander, marbled salamander, wood frog, and or eastern spadefoot toad, is necessary to conclusively define the vernal pool. These areas are essentially breeding habitat and provide other extremely important wildlife habitat functions during non-breeding season as well, for a variety of amphibian species such as wood frog and the spotted salamander, and are important habitat for other wildlife species. 9-20315H. Wetlands under this bylaw includes wet meadows, marshes, bogs, and swamps of all kinds, regardless of whether they border on surface waters as defined in MGL Chapter 131, Section 40, as amended. Except as otherwise provided in this bylaw or in regulations of the Commission, the definitions and terms in this bylaw shall be set forth in the Wetlands Protection Act, MGL Chapter 131, Section 40, and Regulations 310 CMR